Justice Peralta.
Just a few questions. A law, when it's passed by Congress, does not go to the people for ratification, is it not? If Congress passes a bill, becomes a law, the law does not go for consultation to the citizens for approval or ratification, is it not?
Yes, Your Honor.
But when it is a constitution,
Yes.
in order to be effective, it should be ratified by the people.
And of course, the 1987 was ratified, Your Honor.
My question now is, should we also determine what the people understood by the word conception in order to arrive at a proper decision by the court? Because this one was, the Constitution was ratified by the people.
Yes,
It was
yes.
presented to the people.
Yeah,
People voted for it. This is what we understand by conception. So it became the Constitution.
If Your Honor, please, I don't think there's a need to further consult the people on the meaning of conception.
What I mean is, the Constitution is ratified by the people. One
Yes,
of
Your
those
Honor.
presented is this provision, Section 9 of Article 2, is it not?
Section 12?
Nine?
Section...
Section 12, brother.
That's one of the provisions of the 1987 Constitution, and by ratifying the 1987 Constitution, the Filipino people are deemed to have ratified everything in that
That's
1987
why-
Constitution, including Section 12,
That's
Article
why,
2,
if
Your
I
Honor.
voted for its ratification, and this is the meaning of conception, to my mind, to the mind of those who ratified it, shall we not also consider what was in the mind of those who ratified of the people of the word conception, the meaning of conception? They approve it. So if the people ratified it, then we should know what was to their mind the meaning of conception.
Well, nothing probably is going to prevent us from doing that, but there is no need to do that, Your Honor, because that's settled by the deliberations of the Constitutional Commission. And I suppose there were discussions, public debates before the ratification, and the people were informed. I'm sure that was a very controversial provision at that time. And people, I'm sure, were very interested to find out what conception in Section 12 really meant. And so I'm sure there were a lot of discussions on that, and I'm sure it was explained to them that conception refers to fertilization, because that was precisely the constitutional intent.
I am also disturbed by your statement when you were asked by Justice Castillo that if life begins at the time of implantation, then the RH bill is constitutional. Did I get you right? You said yes?
No, I did not say yes. I don't think I had a chance to answer that.
You were asked two questions. If conception simply means fertilized ovum, then this law is unconstitutional because it violates the Constitution. What if the meaning of conception is implantation, then this law is constitutional. That's what you said. Do you understand from what you said?
If Your Honor, please, the protection, the intention here of Section 12 is to protect life from the very moment it exists. And obviously it cannot exist at implantation.
You're changing your answer.
I don't think I made...
Whether life begins at the time of fertilized ovum or implantation, as long as contraceptives are used during that period, this law is unconstitutional.
I beg to disagree, Your Honor. I did not make that statement that when it is at implantation, it is constitutional,
Okay,
Your
so
Honor.
okay, that's what I understood from the questions propounded by Justice Castillo now. You cited Section 7 in relation to Section 24 as unconstitutional. Section 7 of RA 9-10-354 in relation to Section 24 as unconstitutional. This is what you argued.
Yes, Your Honor. It's part of...
But if you read Section 7, I do not find any infirmity, constitutional infirmity. Section 7 is access to family planning. Is there anything wrong if there is access to family planning?
Your Honor, family planning refers also to hormonal contraceptives as defined It's also access to a full range of family planning methods, and that includes hormonal contraceptives, intrauterine devices, injectables, Your Honor.
But we have been, I understand that even before you get married, you are given a family planning lectures, and these are the lectures that you get before you get married. So is there something wrong if we retain this provision, Section 7, as constitutional?
That is not part of Section 7, Your Honor.
Section 7 of RA 91354.
Yes, Your Honor.
In relation to Section 24, Section 24. What I see as an infirmity probably is Section 24. Because failure to follow Section 7 becomes punitive.
Yes. If Your Honor, please, in connection with the topic or the issues I discussed during my oral presentation, Section 7 refers to a full range of modern family planning methods, and that will necessarily include hormonal contraceptives and IUDs, which I said, Your Honor, are abortifacients. So that is what is wrong with that, aside from the fact that
but it's not limited to that. It also include free care and services to indigents.
Yes, Your Honor. Yes.
So what's wrong with it?
Well, insofar as that is concerned, it's not.
That's my question is, you take away the penalties insofar as violation of Section 7 is concerned, there is no more objection. I do not see any infirmity under Section 7. In fact, it is good to all.
If Your Honor, please, Section 24, and that's going to be discussed by the next speaker, refers to, I think, conscientious objection.
No, Section 24, it's in the advisory. I'm reading the advisory.
Yes, Your Honor.
Section 7 of RA 9-10354, Section 7 is the access to family planning in relation to Section 24 thereof.
Right, yes, Your Honor.
So Section 24 penalties for non-compliance with Section 7.
Yes, Your Honor. And
so what's wrong with it?
That specifically refers to, Your Honor, to Section, not Section 23, but Section, Section 24.
You look at your page 2.
Okay. Section 24.
Oh, yeah.
Okay, Section 24.
Section 24, penalties for non-observance of Section 7. So my question is, if you remove the penalties for non-observance of Section 7, is there an infirmity insofar as Section 7 is concerned?
Yes, Your Honor. That's precisely the point, Your Honor. Because full range of modern family planning methods, Your Honor, refers to or includes, the phrase includes hormonal contraceptives, which are abortifacients, Your Honor.
Yes, but also it includes also procedures for poor and marginalized couples having infertility issues who desire to have children. Hindi ba maganda yan? Oh.
But these are supplies necessary reasonable procedures for poor, well, depending on what these procedures are, Your Honor. But our objection to this stems from our general objection, which is that when you say full range of modern family planning methods, Your Honor, they include hormonal contraceptives, IUDs, emergency contraceptive pills, postcoital pills, and other family planning products and supplies, Your Honor, which I have said already are abortifacients and violative of the right to life of the unborn from conception.
I think your concern is that the law does not prevent abortion. I think that's your concern because under Section 9, which you are now objecting, you are objecting to the use of these abortifacient, intrauterine devices, injectables, and so on. There's no guarantee that if you use these methods during conception, you will not be protecting the life of the unborn child.
Yes,
that is your objection. You are afraid that these contraceptives may be used for abortion.
They can really be used as abortifacients, Your Honor, and they are being used as abortifacients,
But
Your
that
Honor.
is conjectural.
The fact that they are being used as abortifacients
It will
and that they can be used as abortifacients, Your Honor, is not conjectural. I beg to
But that will
disagree,
still
Your Honor.
depend. That will still depend on the person. It will still depend on the person.
If Your Honor, please, as I said, the three mechanisms of action cannot be separated. So once you take the contraceptive, not all the time, the contraceptive mechanisms work. Scientific findings point to the failure of contraceptive action or actions of the contraceptive. And so when contraceptive mechanisms fail, there is a third built-in and backup mechanism which is abortive in nature. And so it's built in precisely, it is going to set in when the contraceptive mechanisms fail. And so that is what is abortive, Your Honor. That's what we're saying. So you cannot separate the mechanisms of action, Your Honor. So once you take the contraceptive, you take everything. Well, if the contraceptive actions are successful, then there's no fertilization, no ovum, no problem. But then if they fail and scientific findings point to such failure, then that is where our objection comes in. Because
Now,
that's where the abortive nature
If you remove
comes
Section
in.
9 from RA 9 from this Republica.
Section 9, Your Honor?
Yeah, Section 9, the one that you are questioning as unconstitutional.
Yes.
Section 9 of RA 10354. Below.
Yes.
The RSB law.
Yes,
If you delete this provision, you will still have objections?
yes. If Your Honor, please, if you read the entire, my reading, if Your Honor, please, of the entire RH law, it's written all over the RH law is the mandate for procurement, this widespread dissemination and use of a full range of family planning methods. So there is a mandate for universal access and procurement and distribution of a full range of family planning methods. That's the centerpiece of this RH law, Your Honor.
I'm through.
Justice Del Castillo.
Counsel, just
Yes,
a few follow-up questions on contraceptives.
Yes, Your Honor.
You have identified contraceptives as abortifacient.
Yes, Your Honor.
There are so many contraceptives, and the respondents have taken the view that not all are abortifacient. So to resolve this issue, why don't you identify, why don't you name these contraceptives, and then let's test them.
Okay.
If they're abortifacient, then the issue is settled. So instead of making generalizations that all contraceptives are abortifacient, don't you think that the proper course of action to take is to identify all these? Because practically all drugs are abortifacient, even a simple aspirin. So these are just a matter of degree. So perhaps those that would cause tremendous harm, then maybe we can ban them. But unless we have not identified them, just to say that they're all abortifacient, don't you think that...
If Your Honor, please, hormonal contraceptives. What we're saying is that hormonal contraceptives, okay, which include, the pills and the injectables and intrauterine devices, Your Honor, and the patches, Your Honor, implants, they're proven to be abortifacients, Your Honor. Vasectomy, sterilization procedures, Your Honor, they're also referred to as contraceptives, Your Honor. But they are not abortifacients because they don't, contain hormones, Your Honor.
No, I was just suggesting that so that because the respondents would also come out with their own authorities. So to resolve it once and for all, let's test them.
if Your Honor, please, we also have an objection about giving, of course, I'm sure Your Honor must be referring to delegating the authority to the Food and Drug Administration. So we have a problem with that, Your Honor, because, these hormonal contraceptives are proven to be abortifacients, Your Honor, and...
I'm not just referring to the Food and Drug Administration. My point is, let's put it to test because this is just evidentiary. It's a matter of fact. We cannot make generalizations. They're saying that these are not abortifacient. You're saying they are the abortifacient. Then let's prove it.
Yeah. If Your Honor...
That's just my suggestion.
Yes. If Your Honor, please, may I just, just bring out the very important point that we have always tried to bring out, Your Honor. Section 12, otherwise we forget this. Section 12, Article 2, mandates the protection of the unborn from conception. And that protection is not just from death, but from any risk or threat of harm or injury of any form or degree, remote or direct, momentary or permanent. And it has been proven already that anything, Your Honor, that you introduce into the body that disrupts the, workings in the uterus or the physiology in the uterus is harmful to the fertilized ovum. So...
Yes, counsel, but the protection come in only after, if I may grant you, the fertilization. So, but before that, the unborn is not protected. The unborn is protected from conception. So before that, it's not regulated act.
If Your Honor, please, before fertilization, there is no person to speak of.
Exactly.
There is no fertilized ovum to speak of. There is no unborn that needs any protection, Your Honor, at least under Section 12. So, really, the protection that we are referring to under Section 12 is protection that starts from conception. That is when we say there is already a person in that fertilized ovum that the Constitution mandates that the state protects, Your Honor.
I even concede that upon the meeting of the egg and the sperm, then there's life already. It should be protected. I concede that.
Thank you very much, Your Honor, for saying that, because that's really life there.